All right, this video is about Yick Wo versus Hopkins. So hopefully by the time that you've watched this video, you will have read Yick Wo versus Hopkins, and you will have spent some time thinking about the arguments that are contained therein. So far, what I've been doing in this course is I've been attempting to give you exposure to some of the kinds of legal reasoning that are characteristic of those working as lawyers. And from our module on property law, we saw how law can be used in this kind of adversarial way, where you have a client and you attempt to show how the set of facts implicit in a certain case render them under the purview of one rule more so than they do a different legal rule. You'll have an adversary in that kind of context who attempts to show that the facts of the case fall more squarely under the purview of a different rule. And so you have one kind of legal reasoning, which I'll call adversarial. A second kind of legal reasoning that we've studied in this class deals with an interpretation of a historical document. And what one does therein is they make various arguments that either the author intended something or it would have been understood by an original audience in a certain way, or certain features of a government and the purpose of the institutions of government favor one meaning, which might be attributed to a statute or something like that over another. But what I'd like to do to conclude this course in the next couple of weeks is turn our attention to a final kind of legal reasoning, which I'll call evaluative, right? We didn't have the impression that anything the law says ought to be followed in every context, and there are good reasons for thinking this. One of the most important reasons that militates in favor of us taking a reflective and evaluative stance toward the law is just that the law is the product of people, and people can be bad. People can be fallible. We are fallible human agents who oftentimes make many mistakes. We let our biases cloud the decisions we make, and no less is true of lawmakers than it is for us. And so human nature and our fallibility and propensity to pursue self-interest gives us a reason for taking a step back oftentimes when we look at the law. Of course, it's challenging when you're in the shoes of a student, because all you want to do as a student is learn what the law says so that you can apply it and have some way to navigate life. I mean, there are a lot of complex situations in life, and you look to the law to know what to do. You look to the law to structure your conduct and behavior and how you treat other people, how to order your affairs. But it's important to remember that the law is not necessarily something that will lead us to a right decision or right conduct, all things considered. Like anything else introduced by fallible human agents, it needs to be evaluated and weighed. And why would we think this? Why would we think that the law needs to be evaluated? Well, when we look at history, we find some reasons for pessimism about our ability to introduce fair laws into society to structure our conduct. And one of the most prime examples in my mind of why we might give pause when considering the law involves race and various ethnic minorities. Seems to me that when we look at the way that the law has been used to sort of make racism and other kinds of discrimination permissible in some sense in our society, really should give us reason for pausing and reflecting on whether the laws that we're following in any given context are good and appropriate for us. And so in this last module of the course, what I've sort of wanted to get across is that just because something is the law doesn't mean it ought to be the law. And it's good to take this kind of critical reflective stance toward the law and what it says. So we needn't think that just because something is the law, that it is owed a certain respect or deference or hat tip from us. It might very well be the case that it needs to be revised. And one of the reasons we have for continuing to think about whether the law ought to be revised is this sort of pessimistic induction we might perform when we look back at our history and see ways in which the law has been used for illicit means, particularly to discriminate against various races, people of various races, and other ethnic backgrounds. And so in today's case of Yick Wo versus Hopkins, we'll begin to see a historical example of how the law was used for an illicit purpose. And somewhat encouragingly, we'll see a historical example of pushback against that discrimination, though when you look to history, examples of this sort of are few and far between, I think. So the case for today involves Chinese laundries, which are operating in San Francisco. So in this later period of the 19th century, California saw the influx of many Chinese immigrants who came to California to find work. And over time, one of the things that Chinese immigrants began to do was engage in the laundry business. It was very common in those days to see Chinese immigrants working in the laundries. And what's more, they operated in predominantly wooden houses and wooden businesses. And at first, everything was fine with this. They were carrying on business as usual. But over time, the board of San Francisco began to dislike the Chinese immigrants for various reasons. And we began to see a form of discrimination exercised against these immigrants that was illicit. So to get us into the headspace of what we'll be talking about today, it's important to look first, I think, at this law that was passed by the City Council of San Francisco. Here it is. It shall be unlawful from and after the passage of this order for any person or persons to establish, maintain, or carry on a laundry within the corporate limits of the city and county of San Francisco, without having first obtained the consent of the Board of Supervisors, except the same be located in a building constructed either of brick or stone. So there you have it. Unless the laundry is in a building made of brick or stone, it must be assessed by a Board of Supervisors. They must give their consent for the laundry to operate. And if the owner was unable to procure the assent of the board, they would have to cease operation as a laundry. Well, it's very predictable what happened. For many years, the board did liberally grant to Chinese immigrants permission to carry on operation as a laundry. But after a certain number of years, eventually the board withheld these licenses from Chinese immigrants. But what was suspicious is that there were some 200 plus Chinese laundries that petitioned for approval, all of which were denied. But for every white laundry operator that petitioned the board for approval, just so happened that they were ultimately approved. Now you might wonder, what's so bad about this law? After all, it doesn't say anything that would discriminate against Chinese immigrants. And so how could the law itself be bad? Seems like what would be bad in that kind of a circumstance would just be the discrimination and not the law itself. It's kind of an open question I have about this case. Maybe you do too. Let's continue on to see if this kind of puzzle will ever be resolved. Okay. Yeah, I've I've highlighted again the facts of the case, which are that there are 320 laundries in San Francisco. You get about 240 operated by Chinese citizens working as immigrants or immigrant laborers in the U.S. And then you have the remainder of the laundries being operated by white American citizens. And all of the licenses were granted to white citizens, but not to the Chinese immigrant laborers. Okay. And the case, before it's ultimately heard by the Supreme Court, goes through the Supreme Court of California. And the Supreme Court of California finds that there is no violation of the Constitution here because of some reasoning from an analogous case of Barbier versus Conley, which we'll talk more about in a minute. The basic idea in that case was that certain restrictions were upheld because they were just general police powers. And so the Supreme Court of California seems to be tipping their hat to the idea that this law that I've just read, which vests the ability of a laundry to continue operations in the hands of a board of supervisors which may or may not approve the laundry, that this kind of a law would be permissible because it's a general police power, much like in the case of Barbier versus Conley. But more on that in a moment. Another question you might ask is, how exactly do these Chinese immigrant laborers enjoy the protections of the U.S. Constitution? The Constitution is supposed to be this document that protects U.S. citizens. Well, here's the answer. There is a treaty between China and the United States such that Chinese immigrants or Chinese laborers working temporarily in the United States would enjoy all the rights, privileges, and immunities of the United States as though they were citizens. And for that reason, because of the existence of this treaty between the US and China, the Chinese citizens that were the subjects of this case would enjoy the protections of the Constitution. Now, I think it's good to think about what exactly the result of this case would be. Here's basically what we have in this case. We have a law that says if you'd like to operate a laundry, you must have your laundry approved by a board of supervisors. You have a petitioner who, like every other Chinese immigrant, was denied in their request to continue their operation of a laundry. And you have basically white American citizens whose requests are approved. You have the subject of the case, Yick Wo, being imprisoned because he's unable to pay the fine associated with failing to cease his operation of the laundry. And because he's imprisoned, he's petitioning for habeas corpus. Now, since he's petitioning for habeas corpus, and this case goes all the way to the Supreme Court, what exactly is the remedy supposed to be for him? I mean, you have this law in question that's obviously being applied in a discriminatory manner, but what kind of result is he looking for? Now here, in this case, I think all he's doing is asking to be let out of prison on the basis that he's been treated unfairly. But this is a little bit odd because in the case, what we see is a large protracted discussion about the fairness of the law and the goodness of having a law that may or may not be kind of applied at the discretion of one and only one kind of body of governors or one and only one person, arbitrary law in many cases. So it's very confusing to know what exactly the remedy is supposed to be. Nowadays, I take it that if we were to see a case like this in court, we would expect basically the Supreme Court to strike down the law and any law that looked like it. But in this case, it looks like there's the more modest and limited aim of seeking for relief from the particular punishments that have been doled out. In this case, imprisonment for the cost of the $10 fine that was levied to Yick Wo. So here are the options. The law could be void, or it could be void because it's applied arbitrarily, or they could just be arguing that the imprisonment is unjust. And to me, on my reading of the case, it looks like the petitioner is just asking the Supreme Court to say that the imprisonment is unjust. But what we get are lots of statements about the silliness of the law itself, don't we? So we see at various times people talk about arbitrarily levied power being vested in a single person or body. We see discussion about the merits of that kind of law and how it sort of is incongruous with the idea of limited government set up in the Constitution. We see lots of different arguments like that. At the end of the day, what I think we get is a statement that the imprisonment of Yick Wo is unjust because the law was being applied in a discriminatory manner. We never get the law being struck down, at least in the text that we read. We do get the idea that the imprisonment of Yick Wo was unjust because the law was applied in a discriminatory manner. But this result is obfuscated by the idea that we do see many discussions about the silliness of the law. We see the Supreme Court's willingness to cite a dissenting judge from the Supreme Court of California, who at length discusses why it's a bad idea to have a law that permits arbitrary exercises of power being vested in an individual or a body of individuals. And likewise, we see here something that I would call a structural argument. Recall that there are many different kinds of arguments that would fly when one attempted to interpret the Constitution. There are arguments in which one appeals to what the author intended to say. There are arguments about how an ordinary audience would have understood a law at the time at which it was written. There are also arguments that stem from the purposes for which an institution of government was initiated in the first place. And I think that's what we see here is an argument of that stripe. We see the Supreme Court's appealing to the ideas implicit in the Constitution when they set up the structure of the government. So let's read what they say. Maybe you'll agree with me. When we consider the nature and the theory of our institutions of government, the principles upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. To me, it looks like what the Supreme Court is doing here is appealing to some kind of zeitgeist implicit in the Constitution, some kind of idea of limited government, something about the purpose for which the government exists in the first place. And they're using that to extrapolate to a particular result, which would be the silliness of the law. Although they never do strike the law down, they do note in passing, it seems to me, that something about it doesn't sit very well with the ideas that were enshrined in the Constitution itself, those of limited government and whatnot. Another part of the case baffles me deeply. It's this idea that sometimes a law could be so unreasonable that it conveys along with it the presumption that the legislature never intended to pass it. I don't know how one makes that inference. And I also don't know how to fit this bit of reasoning in to the rest of the case, which all seems to be done in service of overturning the imprisonment of Yick Wo rather than overturning the law itself. It's almost as if the reasoning that gets us to the idea that Yick Wo was imprisoned wrongfully, along the way, all you find are these potshots being taken at the law itself, even though the law itself never seems to be explicitly overturned. There are many statements that seem to show us that the law is silly, that it's incongruous with the ideas of limited government and whatnot, and that it's so silly that it carries along with it the idea that the legislature probably didn't mean to pass it, but we never find the law explicitly overturned in any of the reasoning. We just see all of these potshots being taken at the law, I think. And so here we have another idea that you might think constitutes a rather strange and maybe impermissible inference, which would be an inference from the fact that a certain law strikes us as silly to the idea that legislators never intended to pass it. Well, I don't know. Some of the legislators I know seem to be kind of silly people, and I don't know what kind of stuff they would want to pass. And so I don't know. I don't know what you think about this inference in the case itself. But I think that when anybody reflects back on Yick Wo versus Hopkins years later, nobody really remembers the potshots being taken at the San Francisco law. Nobody remembers the San Francisco law. Nobody really remembers what happened to Yick Wo. Nobody understands that Yick Wo versus Hopkins is really a case about habeas corpus and Yick Wo petitioning for his release from prison instead of his petition for the law to be overturned. What people remember from Yick Wo versus Hopkins is this idea that's been repeated often in recent history, but finds kind of its origin in this rather early intervention into what I think is a discriminatory landslide in American jurisprudence. they hold that even though a law might be content neutral, it could be applied in a discriminatory way. Another way of saying that is that even though you look through a law and you find nothing in particular that is discriminatory or provides explicitly for the marginalization of a certain group of people, it is broad enough to be applied in that way, such that those who execute the law might, with a straight face, try to say that they're just following the law and they're doing what the law permits them to do. And half of the things that these people do in the name of the law, it seems to me, work to the detriment of a certain group of people. Of course, in this time period, the marginalized groups of people would predominantly be ethnic and racial groups, as well as women, of course, too. But the idea in Yick Wo versus Hopkins, at least, is that the law could be neutral on its face, fair on its face, in the words of the court, but be applied with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between people in similar circumstances. This case raises many questions for me. I wonder sometimes how, just a few years later, the Supreme Court could issue the decision in Plessy versus Ferguson, which held that it was constitutionally permissible to require Black people to ride in a separate train car than white people, under the assumption that no discrimination was really being promulgated by any government in that case. In that way, the court maintained the doctrine of separate but equal. Given there are, sociological explanations about how you can get two such radically different statements of the law. I mean, in one hand, the Constitution of the court really did drastically differ from one case to the next, even though it was just a few years later before we got the Plessy versus Ferguson case. In fact, in Plessy versus Ferguson, I think that only two of the justices from Yick Wo versus Hopkins were still on the Supreme Court at that time. So there are definitely sociological explanations. And as the appointment and constitution of the court differed, so too did the decisions that were issued by it. But for here, I do think that Yick Wo versus Hopkins, for me at least, does look like a rather refreshing intervention into what is a typically racist history of jurisprudence in the United States. Some of the ideas that stand from this case will actually come up again and again, I think, in what follows. And so one idea that will become frequently discussed as we continue on with the course is this idea that a law can be content neutral and yet discriminatory. Now, I've chosen race as kind of a test case for us to think about, because I do think that when we think about the racial history in our country, provides us with the greatest reason for pessimism about the law and its utility and goodness. And it might give us pause for thinking that just because the law says something, that we ought all things considered to do it. In what follows, I'm going to have us read some material that I think is interesting and perhaps edifying for us. It comes from the perspective of those who think that race gives us a rather dispositive reason for being pessimistic about the law and would have us constantly re-examine the law in light of the racial failings of our country. Now, of course, this is the idea of critical race theory, which is kind of a bad word in today's day and age. On one hand, you have conservatives wanting it to be sort of expurgated from the public schools, and you have other people who say that it's a completely new innovation and that it's one of the most important ideas that's ever been thought of in recent history. And I do think that the idea probably does. It's quite controversial, and I do think it's in our best interest to kind of get to the bottom of it in the time we have left in the course. And so basically where I'm going with this in the next couple of weeks is that I'm going to present to you some of the ideas from critical race theory that critique the relationship between race and the law in our country. I'll have you sort of learn what those perspectives are. And then on the final exam, what I'd like to do is basically give you a piece of writing, an excerpt from a case that contains some legal reasoning. Then I can ask you to evaluate its merits kind of from the perspective of critical race theorists. And I think along the way, we'll learn a couple important lessons, one of which is the difference between what the tenets of a view might have us believe about the view itself and the things that a particular exponent or proponent, I guess, of that view might say. So it's become all too common to think about, um, any kind of mainline view such as feminism or maybe to use a different example, a religion like Christianity, for instance. You might ask yourself, what is it to be a feminist? And while you might get many different answers to that question, what you'll find when you kind of cut through all the different answers that might be given is this essence in which to be a feminist, you think something about the socioeconomic equality of men and women. You don't think perhaps that men and women are equal in every way in which they might be equal. You might think that men are on average taller and will die sooner than women, but you will think that there's a sense in which men and women ought to be equal in various socioeconomic and family matters. So there is some kind of essence there with respect to feminism. Now, a different question you might ask various people who call themselves feminists is this question about whether one could be anti-abortion and be a feminist. And although many of you will think that there's prima facie nothing conflicting about the ideas of feminism, the essence, and the idea that one ought not have an abortion, many people are divided on the issue, such that if you were to Google this right now and say, can you be pro-life and a feminist, you're going to find a wide array of opinions. And so I'd submit to you that what's going on there is that there is something of a difference between the essence of a view and maybe the things those who call themselves feminists would say in name of that view. Well, I'm a feminist and I believe X about abortion. It might not exactly be entailed by anything in the tenets of feminism itself that one have a particular stance on abortion. Though, of course, there will be many feminists who do have, um, uh, shall we say, what is the word I'm looking for here? A rigorous opinion, a robust opinion about the permissibility of abortion and whatnot. Likewise, I think the case can be made with Christianity, right? There was a televangelist who was quite famous named Pat Robertson. And Pat Robertson said one time that the gay people don't acquire the AIDS virus from sexual intercourse or anything like that. They acquire the AIDS virus by these special rings that they've designed in the gay community to cut into one another's flesh. The ring is supposed to have the AIDS virus on it, and when gay people shake hands, that's how they give each other the AIDS virus. That's what Pat Robertson said at one time, I believe. I've not been able to find the clip of him saying this recently, but I do remember being a college student and watching it. So it's disappeared, but I'm pretty confident he did say this at one point. Regardless, Pat Robertson is a televangelist representing a religion. And, the essence of the religion he represented, when you cut through all the particular doctrinal distinctives that people tout, it seems to be something about Jesus Christ dying for our sins and rising again from the dead, right? And if you believe in him, you'll go to heaven, right? I don't know that much about Christianity, but I do know that much. That seems to be the essence. And there are many different distinctives that people who call themselves Christians might tout. Some people will say that there is some authority of the church that must be recognized somewhere in there. Other people will say something about baptism. I don't know. I don't know enough to tell you, but I do know that the essence of Christianity is something about Jesus dying for your sins. Everybody knows that, really. Now, when we think about the relationship of Pat Robertson's rather absurd statement about the AIDS ring and its relationship to Christianity. What's the correct inference to draw from all that? Well, it seems like Pat Robertson is the proponent of a viewpoint, but some of the things he says have nothing to do with basically the essence of the viewpoint he represents. And so I'm wondering, and I'm inviting you to sort of explore with me whether something similar is happening in the case of critical race theory. Is, in other words, there a core essence of critical race theory that differs somewhat from the things that call themselves critical race theorists might say about particular affairs? So I think that'll be our inquiry for the next couple of weeks. And basically, the final exam that I'll give you will ask you something like that. I'll give you a piece of writing. I'll ask you about what a particular proponent of critical race theory might think about it. And I'll tell you how to sort of synthesize and digest some of his writing. In fact, it'll be the lecture for next time, which will be Derek Bell for tomorrow night. We'll think about Derek Bell and his perspective on race and the law. I'll give you this piece of legal writing to sort of analyze, given Derek Bell's perspective. And then you'll be able to tell me, after I kind of develop something about the essence of critical race theory, you'll be in a position to tell me whether the things that Derek Bell says are directly entailed by tenets of critical race theory, or whether he is just going off on the limb, kind of like Pat Robertson did. So I think that's kind of interesting. That's how I'm going to come at this issue about race and the law. But for now, we've begun thinking about it with this case of Yick Wo versus Hopkins. And regardless of what you make of the legal reasoning itself, which seems to be very sparse, it does seem to me that it is one of the earliest times at which you see a wrench thrown into this racist machinery of jurisprudence in the US. So perhaps it is a comforting step forward, but given subsequent developments with Plessy versus Ferguson, there is again a little bit of reason to be disheartened about the legal history of the United States. So let's keep that in mind for now. We've seen a case from American history in which the brakes were pumped a little bit on white supremacy, right? And we've seen that this idea arose in which a law might be content neutral, but it might be applied in a discriminatory manner, in the court's own words, with an evil hand. In next class's lecture, we'll look at Derek Bell and his particular take on race and race and the law in the United States. So I think it'll be interesting. It's good for us to think about whether the law is correct and to what extent we should follow it. And I think that this will really round off our class when we think about being a bit critical of the law. So I hope you enjoyed this lecture, and I'll talk to you next time about Derek Bell and the piece that's supposed to Carmen. Thanks.